Good evening all. On behalf of MMBA, I extend my warm welcome to each and everyone present here in this evening. We are happy to see you all here together. We are grateful to you for taking out some time to join us in this Quin Decennial lecture series. We hope you will have a great time and you will enjoy the series as you always have here in MMBA. The beginning is the most important part of a work or a task. As per the above quote, we always consider welcoming the guest and the attendees is one of the most important duty of MMBA. To give such a welcome, may I now request the President of MMBA, Advocate Mr. SRINIVASA RAGHAVAN, to welcome the gathering.
Happy evening to all. As we all know well, MMBA has been conducting this lecture series. Mr. Isaac Mohanlal has led the pathway, and the Quin Decennial series has been going on for the past 4 years. Under the leadership of Krishnavani ma'am, it was going on till 2021 February. Then came the lockdown. It was suspended, and MMBA has resumed the session. And last month we had the Chief Justice to inaugurate the session, and Justice P.N. Prakash was pleased to deliver the first lecture of the Quin Decennial series, and of course our judges were there. This is the second lecture of the series of the season 2022-23, and MMBA is very firm in inviting people of eminence, erudition and exuberance in delivering the lecture. And today's chief guest is known for his prowess, knowledge and his experience on the senior counsel. And befittingly, we have Justice Honorable G.R. Swaminathan to be the chief guest to preside over the function. So I wholeheartedly and happily welcome Justice Mr. G.R. Swaminathan to this function, and I welcome Mr. N.L. Rajah, Senior Advocate, to deliver the second lecture. I also welcome Mr. Isaac Mohanlal, Founder President of MMBA, Mrs. N. Krishnavani, Immediate Past President, and senior counsels present here, and more importantly, the audience for whose benefit these lectures are being organized. I once again welcome one and all. Thank you.
It's time to honor. No person was ever honored for what he received. Honor has been the reward for what he gave. May I now request the President of MMBA, Mr. SRINIVASA RAGHAVAN, to honor Honorable Mr. Justice G.R. Swaminathan with a memento. Thank you, Lordship. Thank you, sir. May I now request the General Secretary of MMBA, Mr. K.P. Narayana Kumar, to honor our chief guest, Advocate Mr. M.L. Rajah, with a memento. Thank you, sir. With the award object of imparting quality of legal acumen to the members of the bar, especially the younger members, MMBA has been organizing a lecture series in the name of Quin Decennial Lecture. We invite eminent and erudite lawyers and advocates to deliver the lecture on various topics of law. The first lecture of Quin Decennial Lecture Series of the year 2022 and 2023 was inaugurated by Honorable Chief Justice of Madras High Court, Mr. Munishwanath Bandari, and the first lecture was delivered by Honorable Mr. Justice P.N. Prakash on the topic Law, Courts, Justice from the Spectators Gallery. The second lecture is being delivered today. It is befitting to have the lecture session of the day presided over by the much adored judge of the Madras High Court, who is known for his academic excellence and varied interest in various fields of law. May I now request the Honorable Mr. Justice G.R. Swaminathan to deliver the presidential address.
Good evening to one and all. MMBA has chosen the right topic and also the right speaker. There are quite a few counsel in the Madras Bar whom it's a sheer delight to hear. The diction, the choice of words, the accent, all of these will come naturally to them. I'll particularly name late Shri C. Natarajan, then Arima Sundaram, and then Shri Sriram Panchu sir. To that select league belongs the speaker of this evening. Many of you would have come across his articles in Hindu. They would strike you not only for the chiseled prose, but also for their sheer logic and rigor of reasoning. Friends, 2 weeks back, I happened to meet the Honorable Vice President of India, Shri Dhankar. The moment I introduced myself, he just stopped for a moment and became nostalgic. You said, "You're G.R. Swaminathan?" "Yes, sir, I'm G.R. Swaminathan." "Oh, I remember Govind Swaminathan." Next sec, Govind Swaminathan. He had listened to some lecture of Sri Govind Swaminathan some 40 years back. He was telling me about that. And Sri N.L. Rajah, Senior Counsel, he is from that stable, his junior. And that explains everything. More than you, I consider myself to be fortunate to be present here. Friends, nature has its own way of governing. Whether it be plant kingdom or the animal kingdom, some kind of a software is inbuilt and that cannot be altered. Things proceed with clockwise precision and there appears to be some fidelity to a higher principle. Calamity strikes only when there is human intervention. Not so when it comes to humanity. We need a set of principles to regulate the overall working. Otherwise, it will be rule of might is right. We have read in our student days the principle of Matsya Nyaya, the bigger fish swallowing the smaller fish. This is what is rule of law all about. In the famous Roger Matthew judgment rendered some 2 years ago, the Honorable Apex Court observed that one of the essential ingredients of both democracy and rule of law is an independent and fearless judiciary. When I say fearless judiciary, it means judges who are not afraid of anything, including the social media. There can be rule of law only when we have judges and adjudicators who can take decisions independent of any extraneous influence. If rule of law is absent, there is no accountability and there will be abuse of power and corruption. When the rule of law disappears, we are ruled not by laws but by the idiosyncrasies and whims of those in power. My typist has typed as idiots in power. Maybe. But the question is, how this role is to be discharged by the judiciary? What are the parameters which the courts and judges have to bear in mind? I look at judicial functioning as a part of the overall scheme of good governance. I would request Rajah sir to share his thoughts on how best the judiciary can perform this role. Like all of you, I also earnestly look forward to listening to the respected speaker with rapt attention. Thank you.
Thank you, Lordship. Today's guest, Mr. N.L. Rajah, is a designated senior advocate practicing in the Madras High Court. He was called to the bar in the year 1986 and started his practice under Advocate Mr. S. Govind Swaminathan, the former Advocate General of Tamil Nadu. Today's guest is a former president of the Madras Consumer Court Bar Association and a former trustee and currently advisor of the Citizen, Consumer and Civic Action Group, an organization which is dedicated to create awareness among consumers about their rights and help them in realizing the same. He is an invitee of the International Visitorship Program of the US government in the year 2000. In May 2013, he participated in a week-long deliberation of the United Nations in Seattle to bring out a model contract to regulate online dispute resolutions. He was co-opted by the Justice D.P. Vadva, the former judge of the Supreme Court, to be part of a committee appointed by the Supreme Court to prepare and submit a report to the Supreme Court on the effectiveness of the public distribution system in Tamil Nadu. He is a founding director of the Nani Palkiwala Arbitration Center, a center recognized by the Madras High Court to render administrative assistance in arbitration matters. He is also trustee of the Palkiwala Foundation. He was a member of the committee formed by the Law Commission of India to suggest changes and amendments to the Arbitration and Conciliation Act 1996. The deliberations of this committee were published as the 246 report of the Law Commission. Today's guest has co-authored the book, The Consumer Protection in India, with Justice D.P. Wadhwa, a retired judge of the Supreme Court of India, and published by Wadhwa Publications. He has published a book on the history of Madras High Court titled A 150-Year Journey from a Crown Court to a People's Court, as also a book on the architectural value of the Madras High Court building titled An Iconic Splendor. He is one of the principal contributors to the book Courts of India, published by Supreme Court of India, and that was released on 26 November 2016 by the Honorable Chief Justice of India. He is also trustee of the renowned Dr. M.S. Swaminathan Research Foundation, known as MSSRF, which is an agriculture research institute. He is a former member of the advisory committee of the Tamil Nadu Electricity Regulatory Commission. He is also the member of the management committee of the National College Trichy, which is one of the oldest educational institutions in Tamil Nadu and was founded by his family in the year 1919. He was inducted as a member of the Governing Council of the Cancer Institute, WIA Chennai, by Dr. Shanta during her lifetime. He has written several articles in law journals, also in newspapers like Hindu, Times of India, and Indian Express. In 2018, he was awarded the Service Award by the Ramakrishna Vivekananda Trust for his service without expectation to Cancer Institute, Adayar, and an orphanage Avvai home founded by India's first women doctor, Dr. Muthulakshmi Reddy. In December 2019, the Bar Association of India, an institution established by Dr. Rajendra Prasad, has conferred on him the Living Legend of Law Award. With this few notes, may I now request the chief guest to deliver the lecture on today's topic, Role of Judiciary in Good Governance.
Good evening, friends. Honorable Mr. Justice G.R. Swaminathan, who has honored me with his presence here today, my great good friend and President of MMBA, S. SRINIVASA RAGHAVAN, General Secretary of MMBA, Mr. K.P. NARAYANA KUMAR, past presidents of this august institution, Mr. Isaac Mohanlal and Mrs. Krishnaveni, my friends who had gathered here today to listen to me, I thank you all for your presence today, and I hope I will not disappoint you when I elucidate and expand on this topic, the role of the judiciary in good governance. MMBA is actually the latest sibling in the family of law associations in Tamil Nadu, the karta of which is the MBA, which was started in 1865. But MMBA, the M in MMBA, which is Madurai, is far more ancient than Madras in MBA. The Madurai, it ranks on par with the great cities of the world and the great cities of India, like Benares and Kanchipuram. Mark Twain visited Benares and remarked, Benares is older than history. It is older than tradition. It is even older than legend, and looks twice older than all of them put together. I wish we had allowed Madurai to stay in that state of pristine antiquity. But unfortunately today, remnants of that glorious past remain as scattered gems which are far and few in this sprawling metropole. That's very sad. It is Socrates who observed that the beginning of all wisdom is the definition of terms. So before I go into this topic of the role of the judiciary in good governance, let me ring-fence my presentation to you today to tell you what I will be dealing with. To put it in three simple words, I will be dealing with was, has, and should. That is, what has been, what was the role of the judiciary in good governance, what has been the role of judiciary in good governance, and what should be the role of judiciary in good governance. So let me start at the beginning. What was the role of the judiciary in good governance in ancient India? True it is that there is no concept of the judiciary as we know it today in ancient India or any equivalent thereof. The single important difference is the dispensation of justice in ancient India was a highly decentralized exercise with much activity happening at the village level. This is one of the things in my opinion at least, where the British did some injustice to the system in completely inverting the pyramid. A good system of administration will have one person at the top and 10% at the bottom. What the British system did is, it simply inverted this pyramid. So the effect is, on all counts, you have a few thousand IAS officers in Delhi with one collector at the district level, right? So they did this to the judicial system also. Much of it got centralized in the presidency towns and in the urban areas, and the traditional role of justice dispensation, which used to happen at the micro level, got distorted on account of this. But even when justice happened at the micro level, what we call judiciary today was substituted by judicial principles in the earlier times. There was no single book which contained all these judicial principles as we have the Constitution of India, which supplies the basic framework within which the system operates. But these were once again to be found in a whole lot of literature, whole lot of scriptures, and a whole lot of directive works, mandatory or recommendatory. So this was the basic system, and these principles then came to be applied at the local level whenever there was a question of dispensing justice. So how did this operate? Kindly listen to this. Gather together, speak together, know each other's mind. May your communication and assemblies be unified. May your minds and intellects be common. May your revolution be united and your hearts beat in unison. May your minds unite to make you happy. Without distinction of superior and inferior, these are brothers growing up together for prosperity. I have not read the commentary of the Constitution of India. I have read extracts from the Rigveda Samhita. You have equal rights and articles of food and water. I bind you to the oak to live together like the spokes of a wheel and the hub. Is an extract from the Atharva Veda. That which sustains is called dharma. Dharma holds people together. Hence the conclusion is that which has the ability to hold together is dharma. I am not extracting from a book on sustainable principles. This is a passage from the Shanti Parva in Mahabharata. Indian society since inception was essentially a duty-based society. All aspects of human conduct, from the cradle to the funeral fire, was governed by rules that were compendiously called dharma. This is a passage from a work by Justice Sri B.N. Krishna. In the Jambu Dvipa, Bharat is regarded as great because it is the land of duty in contradiction to others which are lands of enjoyment. This is a passage from the Vishnu Purana, and Mahatma Gandhi echoed the very same words when he said that in contradiction to other nations which were Bhoga Bhumi, ours is a Karma Bhumi. The coronation oath of office of King Veena in Mahabharata reads as follows. Take an oath that by your mind, deeds and words, you shall protect the people considering it as equivalent to the Creator, that you shall act in accordance with Dandaniti and not on your own caprice. This is a passage from Mahabharata and not a passage from Menaka Gandhi versus Union of India. They did not introduce the inadvisability of arbitrary action through judgments of the Supreme Court, but this was part of the DNA of this country. The first clear system of the right to justice is found in Kautilya's Arthashastra, where justice was assured as including a fair trial and the right to produce witnesses. Citizens had a right to trade and commerce, right to inheritance, and to get standard wages. Women's right to Sridhana was recognized, and note this is very important, as was the right of a widow to remarriage, and in some cases even the right to divorce the husband. These were rights which were recognized in Kautilya's Arthashastra. Follow this closely. The king should protect associations of non-believers and believers in the Vedas, of traders, uncultured people equally in the fort and in the villages. This is an extract from Dharma Kosha, which once again a commentary is written by Justice B. N. Sri Krishna, titled British Human Rights Jurisprudence. Regarding appointment of puisne judges, the Narada Smriti stipulates, let the king appoint as members of courts of justice honorable men of tried integrity, who were called Sabhayas, who are able to bear the burden of administration of justice and are well versed in the sacred laws, rules of prudence, who are noble and impartial towards friends or foes. This again is an extract from the Narada Smriti. Interestingly, ancient India was so developed that it even had institutions which are similar to the Law Commission of India. They were called Nyaya Parishad, which were a congregation of scholars learned in the Vedas, the Mimamsas and the Vedangas. And like the Law Commission of India, the Nyaya Parishad was able to assist by providing research-based advice on controversial issues when the law was not very clear. This is an extract from a commentary on Yajnavalkya by an author called Robert Lingat. The equivalents of modern day advocates were also in existence in ancient India. They were called Niyogis. The legal service of the Pradinidhi or Niyogi, who were of independent character and great learning, would be availed by the litigant parties, which you find in the Narada Smriti. What about pleadings? The four main aspects of a judicial proceedings, according to Narada Smriti, and a commentary on which has been written by Justice Rama Joyce, says the four main aspects of a judicial proceedings are Purva Paksha or Pratijana, which is the plaint, the Uttarapada or Kriyapada, which is the written statement, the Sadhana, which is the evidence, and ultimately the Nirnaya or the Jayapatra, which is the judgment which is issued by the king. Adjournments, according to Katyayana Smriti, about which again Justice Rama Joyce has written, if a litigant desires to obtain a long-term adjournment merely under some pretext, that should be regarded as deceitful and is declared to be a reason leading to the loss of his case. The rule was applicable for both the parties. The concern for avoidance of judicial delay was of a high order and the mechanism was effective. This is a commentary once again by Justice Rama Joyce when he writes a commentary on the Katyayana. Katyayana then goes a step ahead and declares that a fine should be imposed upon the Chief Justice and the Sabhayas in case they have a conversation in private with the litigant. Now, all this therefore leads to a very renowned jurist called John Spellman, who is a jurist in the Oxford University, to comment, in some respects the judicial system of ancient India was theoretically in advance of our own today. Now, the question would be, now was all this concentrated in some geographical locations in India, or was it spread right through the country? Right? The answer to that lies in a statue which every judge entering the Madras High Court sees the first thing in the morning, and that is the statue of Samanidhi children. However high you may be, the law is above you is a statement that is attributed to a jurist called Thomas Fuller. But 2000 years before Thomas Fuller even existed, a king called the Samanidhi Cholan actually put this principle to practice. And even when the person who was hauled up before him happened to be his own son, he did not show any impartiality, he did not show any bias, and allowed the course of the trial to go unhindered and the punishment to be meted out without any bias. So this principle that howsoever high you may be, the law is above you, did not originate from England. It originated, we possibly did not spell it out in such elegant prose, but it originated in our country and was in fact implemented in India. So therefore, these principles were fairly uniformly spread all over the country. The Hall of Justice in the Tamil kingdoms was known as Avaikalam. They were also known as Dharmasanam. Evidence also shows that there was then a court of justice known as Mandram in chief cities where both civil and criminal cases were taken cognizance of, tried and decided. What was the corpus of law which these judges depended on to administer justice? These were called Dharmanu. In more than one place in Silappadigaram, it is said that if justice was not properly meted out, the king would not survive. This is in fact mentioned as the chief characteristics of the Pandya kings. With such a high sense of justice, then the Tamil kingdoms left no stone unturned to mete out proper justice to the wronged and the innocent. There was a special department of justice composed of learned and the wise. The king was, of course, the higher court of appeal. The availability of access to justice, which we today believe is a modern concept, was very much a part of Tamil culture. If you look at the statue of Samanidi Kandacholan, the cow's mouth is on a rope which leads to a bell. That bell used to be called the Araichi Mani. The Araichi Mani is equivalent to our Article 226 and Article 32 jurisdictions of our courts. Right? So any aggrieved citizen could go and bring that Araichi Mani. And the king had to then come out and attend to the grievance of the aggrieved litigant. So this is a concept which is not new to the country, but Araichi Manis were the equivalent of our Article 226 and our Article 32 jurisdictions which we exercise today. Kannagi in Silappadigaram, after narrating the incident of Samanidi Kandacholan to the Pandya king, says, "Thus was justice meted to all. This is the place from which I hail. This is the justice we have known." So this observation goes to show that the citizens considered dispensation of justice to be integral to good governance. There is a description of a trial in the 12th century work of Sekizhar's Periya Puranam, a trial against the celebrated Saiva saint Sundara, who lived during the 9th century AD. A reading of this trial shows that what an advanced justice delivery system that we had even at the panchayat level. Today, people very derisively say, கோர்ட்டுக்கு வந்துட்டியா உனக்கு என்ன பஞ்சாயத்து பண்ணி கொடுக்கணுமா? Panchayat was not what we think it is. Please read Periya Puranam. Look at that story as it evolves. What happens? The Lord comes in the form of an old man and demands, and Sundara is just about to get married. And the Lord says that your grandfather has pledged your entire lineage to me. Right? And Sundara asks him, what is the evidence of that? And the Lord produces a Volachuvadu and says, it is in this Volachuvadu your great-grandfather has pledged your entire family to me. So, Sundara refutes that. The matter is taken before the Panchayat. So, the first question Sundara says is, if my grandfather had given this Volachuvadu in a different village, why are you bringing up the matter before this Panchayat, jurisdiction of the Panchayat, section 20 CPC, right? And then the Lord says, but you are residing here. A suit can be instituted in the place where the defendant resides. So the Lord says, you are residing here, therefore I have brought it before this Panchayat. So the Sundara says, what evidence? Then he produces the Volachuvadu. So Sundara grabs that Volachuvadu and tears it away. And the Lord says, this is only secondary evidence. I've got the primary evidence kept safely. Right? So the evidence, the description of the trial shows that we had a very advanced justice delivery system even in those days. So my endeavor here is to point out that this concept of delivery of justice in a speedy manner, in a most affordable manner, and in an acceptable manner was very much part of the DNA of our system from ancient times in India, uniformly all over the country. Therefore, in the ancient time, justice delivery system was part of good governance, even though judiciary as we know it today was not in existence at that point of time. The difference between Western culture, Western civilization and our own civilization is that in Western civilization, as jurists have spelt it out so succinctly and so in such simple terms, law was the command of the sovereign, that's all. If the king chooses to rule in a particular way, that became the law. But in India, it was not so uncomplicated. The king obviously was the fountainhead of all authority, including judicial, but the king himself was subject to several rules, regulations, and these percolated down to the lowest level, and therefore judiciary had an important role to play in the administration of justice. And this is just not in respect of some village panchayat with regard to land. Please go into the website and read about an entity called SRINI, SHERNI. You will be amazed. SRINIs are actually the ancient equivalent of our chambers of commerce. But look at the extent to which they were evolved. The SRINIs, there were different SRINIs which were constituted in respect of different types of trades. In respect of certain types of trades, they were completely excluded. But in all other types of trades, the dispute used to be resolved only within this Chamber of Commerce. The ICC, International Arbitration Center, and the International Chamber of Commerce today has an arbitration center. We practiced this 2000 years back. And look at the nature of disputes that used to come before SRINI. Protection of copyrights used to come before the SRINIs. Artisans could file cases against those whom they felt were copying their designs. That is the nature, to the extent to which we think that our commercial codes are creation of modern statutes. No. If you read about SRINIs, you will find their enormous growth, their enormous contribution to the growth of trade and commerce. It is only this framework which ensured that in 1800, India's share of the world GDP was a whopping 23%. Between China and India, in 1800, we had 50% of the world's trade. But when the British left us in 1947, this had crashed to a miserable 3%. So there was the system of justice, there was the system of trade and commerce, there was justice which was meted out in respect of family disputes, there was justice that was meted out even with, in respect of claims that were made by rivals, and all these had to conform to certain judicial principles. Therefore, the dispensation of justice in ancient India, well down till the time the British took over, was extremely well organized, well accepted, and well delivered. Now let us come to the second stage. The second part of my presentation is actually going to be that the second part of my presentation, as I told you, the first part of my presentation was how was the role of the judiciary in good governance. The second part is what has been the role of the judiciary in good governance. In 1947 and after, and in 1950, we adopted the constitution of this country. So this part which I am going to elucidate on has 4 subsections, so to say. The first subsection is, how has the judiciary established its position in constitutional governance? Second, what has the judiciary done to occupy space in the legislative sphere? Third, what is the role of the judiciary in executive governance? And very importantly, what has been the role of the judiciary in the political landscape, right? So these are the 4 subsections that I will deal with. Till 1970, the Supreme Court was very clear that is only a mere umpire in the game and is not a participant to improve the standards of governance. This is a concept it had till 1970. But came 1970 and there were several challenges to constitutional governance, and therefore it seized the opportunity to set for itself a steel frame from which it will operate. All of you know what happened during that, as students of law. You will know that originally in Shankari Prasad versus Union of India, the Supreme Court, a constitutional bench held that any act passed by Parliament under its amending power under Article 368 would be valid even if it abridged any of the fundamental rights contained in Part 3 of the Constitution. This view was reinforced in 1964 in Sajjan Singh versus Rajasthan, when the Supreme Court parroted this observation that it had given earlier. Then came Golaknath versus State of Punjab, where it took a diametrically opposite view and said that fundamental rights are given a sacrosanct position in our constitutional scheme of things, and therefore any attempt to alter the fundamental rights would be unconstitutional. Now, the executive was furious, right? And if you look at the election manifestos that have been brought out by the ruling party at that point of time, out of the 10 declarations in the manifesto, 7 related to amending the constitution drastically. So this, I would say, was one of the main reasons why the Supreme Court decided to take a hard look at the powers of the government to amend the constitution, which it did in the famous case of Keshavananda Bharati versus the state of Kerala. In Keshavananda Bharati versus state of Kerala, the Supreme Court made bold to say that yes, you do have the power to amend the constitution, as so wonderfully put by Justice K.K. Matthew. The fundamental rights are a cup into which every succeeding generation pour their aspiration. So you can't say at some point of time it is stratified. Succeeding generations will want something different, and you can't say a previous generation was much wiser and what they decided will hold forever. So the Keshavananda Bharati case came up with a very ingenious compromise between the two and said, yes, you do have the power to amend the constitution, but that power to amend the constitution is subject to the basic structure of the constitution theory. So it set the framework and tested the waters to see how the executive will react. Executive did react very vehemently. There was even an attempt to review the Keshavananda Bharati case, and Justice Khanna records in his memoir that Palkiwala's speech before the court, asking the court to abandon this ill-advised move to review Keshavananda Bharati, was one of the finest arguments ever placed before the Supreme Court, the likes of which Supreme Court will never see again, right? So this was a stunning argument that Palkiwala placed before the Supreme Court as to why Keshavananda Bharati should not be reviewed. And in any case, he said, who asked for this review? Which state asked for this review? And the Chief Justice of India very conveniently tried to throw the blame at Govind Swaminathan and said, Mr. Govind Swaminathan, State Advocate General of Tamil Nadu, asked for the review. My senior stood up and said, I never asked for anything like that. And with that, the Keshavananda Bharati review attempt collapsed. Right? So, having tested the waters, the Supreme Court sat back to see how the legal world would react, how the executive will react, how the legislators would react. The legal world, there was a section of the legal world which welcomed this. There were also constitutional pundits like H.M. Sirvai who said this is complete nonsense. You can't have the Supreme Court ruling that there is a basic structure to the constitution, and what that basic structure is we don't know. So this is not something acceptable. Nevertheless, the basic structure came to stay with the power that the Supreme Court derived from the basic structure. The next foray it made into the constitutional sphere was in Indira Gandhi versus Rajah, when the constitutional bench annulled clause 4 of Article 329A of the Constitution. Article 329A paragraph 4 was found to fall outside the amending powers of Parliament, since by adopting separate and special provisions regarding elections to Parliament of the Prime Minister and the President, it destroyed the basic structure of the Constitution. Then in Minerva Mills, it went a step forward and said, Section 4 of the Constitutional Amendment Act 42 is outside the amending power of Parliament and is void since it damages the fundamental or essential characteristics of the Constitution and destroys its basic power. P. Sambamurthy was a state of Andhra Pradesh. It took one more bold step forward and declared unconstitutional and void clause 5 of Article 371D, together with the provisions of clause 5, provided that the order of administrative tribunal that definitely ordered a case shall become effective only after its confirmation by the state government or at the expiry of 3 months from the date of the order, whichever is earlier, to be unconstitutional. In L. Chandrakumar versus Union of India, the Supreme Court held that clause 2D of Article 323A and clause 3D of Article 323B to be unconstitutional, to the extent that they exclude the jurisdiction of the High Courts and Supreme Court under Articles 226 and 227 of the Constitution. Therefore, the power of judicial review by these constitutional authorities came to be accepted as part of the basic structure of the Constitution, empowering the courts even more in their quest to define good governance and to push the agenda for good governance. Not only that, I would say that all these judgments did not contribute to good governance alone. They set standard benchmarks to ensure that bad governance was nipped in the bud. So that is a significant contribution. Once again, in Kiloto Holohan, the Supreme Court overturned para 7 of the 10th schedule and invoked the doctrine of severability to support the remainder of the paragraphs of 10th schedule. And ultimately, in the Supreme Court's on record Association versus Union of India, the Supreme Court Constitutional Bench with a 4-1 majority stated that the 99th Constitutional Amendment and the National Judicial Commission were unconstitutional because they violate the basic structure of the Constitution. So this is what the Supreme Court's journey has been to ensure that its position in the constitutional turf remain unassailable. So today, it is true that the Constitution is supreme. The Supreme Court accepts that. But it is also true the Constitution is what the judges say it is. So there is, this is a position that is the jurisprudence of this country, but the Supreme Court has by and far been extremely reticent to just push its agenda wherever it wants, and has been selective. So it has given itself its power, but that power has been always exercised with a lot of self-restraint. There are certain questions which are still larger questions which have been asked all over the world, and most people are amazed that there is a Supreme Court in this world which can actually turn down a constitutional amendment which has been passed, as we all know how difficult a constitutional amendment is to pass. So with all these members of the political class voting in a particular way, is it left to a few people sitting in the Supreme Court to completely overturn it on the basis that it is not in line with the Constitution? That is why they say the Constitution is what the judges say it is. Now let us look into the judiciary's foray into the political turf. There were certain areas which were left untouched because they were considered to be political turf for a long time. One of them is Article 356 of the Constitution of India. Right? Several times in the past, Article 356 jurisdiction has been invoked, starting from the dismissal of the Namboodiripad government in Kerala. Several times Article 356 has been invoked to dismiss governments. The imposition of the President's rule was held to be a holy cow, and nobody could touch it, and the judiciary had to adopt a hands-off attitude. All this changed with the state of Rajasthan versus Union of India in 1997, 3 SEC, which legitimized the discipline, which made the dismissal of the governments under Article 356 a matter of judicial review subject to the powers of the Supreme Court, but it upheld the dismissal of 9 state governments and dissolution of state legislatures by the Janata government in 1977. Now we went a step forward in SR Bommai versus Union of India in 1994, 3 SEC. The question of the President's satisfaction and powers came to the fore in examining whether the powers vested under Article 356 had been properly exercised, and the Supreme Court then laid down that Article 356 powers are available for judicial review before the judiciary, and there appear to be no limitations placed on that extent of review. So we then have the scenario where the Supreme Court quite effectively occupied the political turf. The other issue on which there has been a seesaw battle between the executive and the judiciary is on the question of reservations. The reservations undoubtedly are largely a political issue based on certain socio-economic factors. That is undoubtedly so. But even in that turf, the Supreme Court has not said that I will not step into this because it is a political turf. And in Indira Sahni, it laid down various rules and regulations. Importantly, it brought into existence the concept of a creamy layer. Right? And interestingly, after Indira Sahni number 1 judgment was passed, Kerala state government passed a declarative statute to say that Kerala has no creamy layers. It's very simple. It simply said Kerala has no creamy layer. Kerala as state, you would all know that the state of literacy in Kerala is higher than the state of literacy in the city of New York. Right? In such a state, the state legislature passed an act to say that there is no creamy layer in this state. A very interesting position which came up before the Supreme Court for consideration of the Supreme Court, and the Supreme Court had cause to remark, unfortunately, today is a matter of political expediency. The governments tend to knowingly violate the rule of law and the Constitution and pass on the buck to the courts to strike down the unconstitutional provisions. It would then become easy for the government to blame courts for striking down the unconstitutional provisions. The case on hand is a typical illustration of such an attitude. In the present case, the state of Kerala did not care if its chief secretary was to go behind the bars. It did not care if the real backwards were left in lurch. When governments unreasonably refuse to eliminate creamy layers, the backward classes are where the government tend to include more and more castes in the list of backward classes without adequate data and inquiry. A stage will be reached soon when the whole system of reservation will become farcical and a negation of the constitutional provisions relating to reservations. We earnestly hope that the constitutional provisions will not be converted into citadels for unjustified damage. So this, again, it had a pitched battle with the political politicians or the political space, and asserted its hold on what it felt was the right thing to do. Now let's come to the executive turf, which has been easier for the court. All these are, I'm giving you samples because the paucity of time, I can't go into detail into the several forays that the court has made into the political sphere, especially in the PUCL case where they said that political parties and people who contested for elections have to declare their antecedents, are very bold steps that the judiciary took in reaching out to the political turf, occupying space, refusing to budge, asserting it, and ensuring that it became part of the law. Now, the easier battle that the court has had to fight is in the executive turf. Article 21, if you really look at it, is a colorless article, right? It is insipid, it is boring, there is no life in that article, even though it leads with the right to life, right? But its scope has been expanded by the courts unbelievably. Where the threat to life is immediate, the court can intervene. Pre-trial release on personal bond without surety should be allowed where a person to be released on bail is indigent and there is no substantial risk of absconding. Child offenders are entitled to speedy trial. Compensation be awarded to dependents of persons killed and injured in firing on persons of backward classes. A punishment which is too cruel or tortuous is unconstitutional. Inordinate delay by the state in bringing an accused to trial or in preferring an appeal against the acquittal violates Article 21. If an accused person, at least where the charge is of an offence punishable with imprisonment, is entitled to be offered legal aid, the counsel for the accused must be given sufficient time, facility for preparing the defence. Breach of safeguards of fair trial would invalidate the trial and conviction. Right to livelihood is an integral part of the right to life. Right against solitary confinement, right against bar fetters, right against handcuffing, right against custodial violence, right against public hanging, so on. And the cases are innumerous, the various areas into which they have gone, especially in environment protection. So there is an imaginary tale told where the Attorney General of India was exasperated with the Supreme Court's, ingress into these various areas and calling them an infraction of the Article 21 rights under the Constitution. So there's an imaginary tale told that the Attorney General goes to the Chief Justice of India and says, "My Lord, would the court kindly classify all cases where it feels that there is an infraction of Article 21 rights?" And the Chief Justice smiles and says, "Yes, we will do it on a case-to-case basis." So there is no definite boundary to this, and these boundaries are constantly evolving and adapting themselves to the new. I always say, I don't know how many of you would have read of an Australian scientist who has moved the court at the age of 103, demanding that his doctors must put him to death. Right? So there is going to come a day when within Article 21 will also include the right to die, right? The circle will, the dot will come a full circle, where, because you read Noah Harari's works, he says that this is going to be a great problem for the globe. At 65 or 60 or 65 people retire, and they have nothing to do for 1/3 of their lives. They are going to be sitting back twiddling their thumbs with nothing to do. So they are unproductive. They don't know what to do with their time. Society can't put them to economic use. Society can't extract manual labor from them. So what are nations going to do? This is going to be a great problem. And as science advances, technology advances, people are going to live till 110, 120. Even whether they like it or not, they will live till 110, 120. So you will, in about 20 years' time, have people knocking at the doors of courts, demanding that they have a right to die, which will then be interpreted by the courts under Article 21 to include the right to life. So we possibly will reach that situation also. So the foray of the judiciary into the executive sphere has been humongous. Then let us come to the legislative turf. Did the judiciary leave that untouched? No. In Visakhapatnam state of Rajasthan, Supreme Court said that gender equality includes protection from sexual harassment and right to work with dignity, which is a universally recognized human right. The common minimum requirement of this right has received global acceptance. In the absence of domestic law occupying the field, to formulate effective measures to check the evil of sexual harassment of working women at workplaces, the contents of international conventions and norms are significant for the purpose of interpretation of guarantee of gender equality, right to work with human dignity in Articles 14, 15, 19 and 21 of the Constitution, and the safeguards against sexual harassment implicit therein, and for the formulation of guidelines to achieve this purpose, in the absence of enacted law to provide for effective enforcement of basic human rights of gender equality and guarantee against sexual harassment and abuse, more particularly against sexual harassment at workplaces, guidelines and norms are hereby laid down for strict observance at all workplaces or other institutions. So the foray of the judiciary into the legislative sphere, also in furtherance of good governance, happened in Vishaka, and then it is also followed in Lakshmikant Pandey versus Union of India. To order to fill up the legislative lacunae, the court set up rules which were part of the obiter dictum of the judgment to regulate the process of adoption of children. So the judiciary has now walked into that area also. And in the Kerala Educational Bill, and state of Gujarat and another versus St. Stephen College are once again forays of the judiciary into the area of education also, and the rights of minorities, where there is an element of judge making. So the Supreme Court in Sarojini Ramasamy versus Union of India quite pithily observed, it used to be disputed that judges make law. Today, it is no longer a matter of doubt that a substantial volume of the law governing the lives of citizens and regulating the functions of the state flows from the decisions of superior courts. There was a time, observed Lord Reed, when it was thought almost indecent to suggest that judges make law. They only declare it. The last few words are indistinct. But we do not believe in fairy tales anymore. So this has then come to be part of the powers of the judiciary. Now, I have dealt with the second part of my presentation. The third part of my presentation is, where do we go from here? Right? Now, let us look at the state of the nation. Where are we? What is our nation today? I do not want to read out a report of the drain inspector's report, as Mahatma Gandhi called it. Right? So it is very fashionable to go to some international forum and read about everything that is horrible about India. I don't intend to do that. Let me start with all the positive things that we have achieved in the 75 years of independence. We are today the world's largest democracy. We are an active, vibrant, thriving democracy of 91.2 crore eligible voters. No country has that advantage. Second, today we are the fifth largest economy after the US, China, Japan and Germany. India's food grain production has increased 500% from 1950 to 51. There has been a 7-fold increase in the highway network in the country. As of April 28, 2018, all inhabited villages in India have been electrified, the last being a village called Laisarg in Manipur. India holds the first rank in milk production. India holds the third rank in egg production. 18.3% of the population was literate in 1951. Today, it is 74.4%. The number of schools have grown up 10 times from 1.4 lakhs in 1947 to 15 lakhs as of now. These are all on the positive side. But that would be giving us a false sense of pride if we also do not point out the fact that public sector in India today is often the private sector of those in public office. Pelf, privilege, patronage, petty tyranny and nuisance value are often the manifestations of power over the public purse. Look at the various scams which are still remain unsolved. The Telgi scam, the murder of Satyendra Dubey, the escapes and misdeeds of Ranjit Dawn, who leaked every conceivable question paper. He never left, he was never partial with regard to that. Any question paper, you contact Ranjit Dawn, you can get a copy of it, well before the examination starts. The warrants of arrest issued by the Ahmedabad magistrate against President APJ Abdul Kalam and the then Chief Justice of India V. Kare, the CGHSM in several cities plundering the public exchequers, all these constitute compelling empirical evidence that corruption is shifting from the traditional license permit areas to the core areas of state functioning. A recent study of the Association of Democratic Rights revealed that 40% of the members of the Rajah Sabha have criminal cases. I'm talking about the current Rajah Sabha, while 12% have serious criminal cases against them. The report has been prepared on the basis of affidavits filed by the contesting parties before the Election Commission. In 2017, the Supreme Court, once again in a measure to improve the standards of governance, established special courts to try these offences. The number of offences in those courts, as the amicus curiae report reveals, has increased from 4,122 to 4,984. After the elections in Maharashtra Assembly, a Don called Arun Gawli gets elected to power. He has several cases pending against him. Pappu Yadav, I don't have to tell you about him. They don't need the support of any political party. They get elected independently and he is known to be leader. There is no question about it. Everybody knows that he is a gang leader and he gets getting elected in every election. Compare this to the scenario when Dr. Manmohan Singh would find it impossible today to win a corporation ward election. Right? A person as renowned, as learned, and as respectable as Dr. Manmohan Singh can't win a corporation ward election today. This is the state of our politics. A house owner who cannot get her property vacated even for self-occupation and the owner of a small plot of land who cannot evict a land shark have no realistic legal recourse in this country today. Most people prefer to swallow injustice, which is a very, very dangerous offshoot of failed justice delivery system, and suffer silently. A few have the means or are desperate seek rough and ready justice through brutal methods and through local dons. There are some 700 and odd districts in India today, and there is studies from human rights organizations which show that the Naxalite movement grows in those states where the system of justice is dwindling. So there is a direct correlation between lawlessness and our inability to deliver justice quickly and effectively. While there is always some news or other of docket explosions, we hardly pay enough attention to docket exclusions. Right? Today, there is a large part of our population who don't go to court. Why large population? If I have a legal problem, I will think 100 times before filing a suit. As a lawyer, I am telling you. We are unfortunately putting ourselves in a situation where this process, we go to court with X number of problems, right? When we go to court, we expect there is a X minus equation that emerges. But today, the legal system is X plus. That is, the legal system itself becomes part of the problem. It doesn't become part of the solution. So we must move towards a system where the litigant is promised an X minus at least to some degree, where he comes with 10 problems, when he goes home, he at least has 8 problems or 7 problems. He can't come to court with 10 problems and the court system itself becomes the 11th problem. Right? That is a system which is dangerously setting it, which we must take pains to avoid. In a civil court, even if you are lucky to get a decree, an execution petition has to be filed, and another prolonged, as Nani Palkiwala lamented, that you are very unlucky to get a decree in a civil court, because then your problems start afresh. But the local don will ensure settlement of the dispute for a price within a few days, and his verdict is enforced instantly. No wonder many people see crime lords not as villains, but as saviors. It's no secret that many banks and financial institutions were engaging these musclemen to collect money, till the RBI came down heavily on them and said that you can't do it. While constituents are kept relatively happy by good deeds and selective intervention, the legislator's influence is largely deployed for the posting of pliable bureaucrats and transfer of inconvenient officials, distorting market forces and undermining fair competition in contracts, tenders, and public procurement. You don't have a national law which covers all public procurement. There are only 5 states in the country which have a law equivalent to the Tamil Nadu Transparency in Tenders Act. Only 5 states have that. So public procurement still continues to be a large avenue for corruption. And as YB eats, the poet lamented, the best lack conviction and the worst are full of passionate intensity. Even now our vision of education is merely increasing enrollment of school children and reduction of dropouts. Quality of education, high productivity of citizens, and seizing opportunities that the modern world offers do not even enter our public discourse. There is an excellent book by a person called Farid Zakaria. Since Justice Swaminathan and Justice Anand Venkatesh like to read these books, I'll try and pass it on to them. Farid Zakaria says this. He says that in the last 150 years, the battle was between capital and labor, right? So you had governance which developed around economic principles, right? It was almost as if the household is setting virtues on the basis of the income it makes. You can't set a household virtue on the basis of the income you make. You can't say, when I earn 1,000 rupees, my virtue will be this. When I earn 10,000 rupees, my virtue will be different. But that was also happening to the world. 150 years, the battle has been between capital and labor. But today, it is very easy for a person who has a factory in China to get capital from a person sitting in Manhattan. And it is easy for a person sitting in Manhattan to finance a textile unit in Karur, right? So these walls, these strict walls of capital and labor have all been disseminated. Now, what is going to spell out the supremacy of nations? There are only 2 things. There are only 2 things which will set out how a nation is going to be supreme. One is our access to energy, right? Like solar energy, our access to various forms, wind energy, solar energy, oil, fossil fuel, all this, our supremacy will be determined on what easy access. This is why you see the Russian war, Russia fails to supply gas to Europe, Europe is going to freeze. In the next few months, Europe will freeze if Russia does not supply oil, gas to Europe, right? So our supremacy is going to be determined on the basis of access to energy. The other thing which will determine is ideas, right? Ideas will shape nations. Ideas must be generated in universities. It must be generated in schools. When Steve Jobs first got a patent for the cell phone, he shipped the order to China. Ultimately, China manufactured some 2 million pieces and sent it back to US. When it was put in the market, Apple got $275 for every phone that it sold, of which $35 went to China, $240 went to Apple. So that is the power of ideas today. We need to generate ideas. We need to, how many institutions, how many colleges and universities file patent applications? Very few colleges. So we have not put a single world-class product in the market today, right? So that is where we are today, and the judiciary must bear these factors in mind when it delivers justice, because it must deliver a justice that sustains that ecosystem. If it does not sustain that ecosystem, the country will just go down the drain, right? That is why the role of the judiciary is so extremely important. Before I end, I am no great thought leader on all these things, but I would like to, as Justice J.R. Swaminathan said in his opening remarks, my own thoughts on what the judiciary can do to prepare itself for the challenges ahead, which are going to arrive soon, if not later. First is, we need to have a master plan of how we deal with our backlogs, right? We can't be doing this in some sporadic, knee-jerk reaction manner. We need to have a master plan. Let that master plan not be ambitious. Each court has so many backlogs. What will we set milestones? Set realistic milestones and see that we achieve those milestones. This is something that we need to do. Otherwise, as Palkiwala lamented, in a budget speech he lamented, it is not as if the country has lost the way, it has also lost the map. But today in the judiciary, the sad part is, we don't know the way, we don't have a map, right? So this is something that needs to be addressed. We need, and we, when I say we, it is all of us, right? More so the bar, because judges have maybe in their seats for 5 years, 6 years, 7 years, 10 years, 12 years, but it is the bar that is always here. And it is the bar which must take up these responsibilities and make a nuisance value of yourself. It's all right. There are 10 judges before whom you will place it. 6 of them will think that you are a nuisance. 4 will react and you will find a solution to your problem. And that 4 will supply a solution to the problem, right? So we need to make a nuisance of ourselves. We need to demand a master plan for disposal of backlogs. And because if we do not have access to justice, there is nothing that we can be proud of as a nation. The second is integrate more technology into the institution. Today, my fear is that ultimately, how do you eliminate corruption? There are only 2 ways in which you can eliminate corruption. The first is that you must reduce man-to-man interface, or man-to-woman, woman-to-man, whatever. Human being to human being interface, you must completely eliminate. One minister did this, Madhav Rao Scindia. He said that railway bookings will be completely computerized. Right? All of us know how we used to do it earlier. Go 10 minutes before and give that ticket collector 100 rupees more. 100 rupees is possibly a very conservative sum I'm talking about, something more. He will give you a ticket. Right? Madhav Rao Scindia said, no, nothing doing. We will automate the entire process. And that 99% has eliminated corruption in ticket bookings. Right? The second is the supply far outstripping demand. Example, telephones. Right? For us to get a telephone, we used to apply, wait for 6 years, 8 years. The supply never did happen. And when it happened, it was a cause for great celebration in the house. We would invite all the friends and host a dinner because we got a telephone connection. But today, if I order a telephone and keep the receiver down, the telephone is in my hand. The connection is in my hand. Right? So demand should supply should far outstrip demand. These are the only 2 ways. I am constantly seeing that in many central government departments at least, there is infusion of technology. Take your tax returns, recent tax returns. I was amazed that my tax returns were cleared within a week. I was asked to pay something more. I paid it. The tax assessment for that year is over. My wife got a refund. Right? All that within 10 days of the tax returns being filed. Now, slowly, technology is going to make inroads into all aspects of human life. My fear is that the judiciary alone is going to stand out as an island in this. So, the judiciary must look at how it integrates technology into justice dispensation at all levels. It's just not online hearing. There are zillion things that you can do by integrating technology. Justice Mr. Nariman, sorry, did it take me too much of the time? Mr. Nariman, in 2003, he drafted a Judicial Statistics Act, right? Every case that comes into the docket in the High Court is classified, is given a code, right? And then it is sorted and separated. Take the Madurai bench of the Madras High Court. If you just take this one simple point, violation of principles of natural justice, I am sure there are some 5,000 writ petitions pending. From 2003, 2012, 2015. Ultimately, the court hears the matter in 2022 and says, violation of principles of natural justice, send it to the person who ought to have heard it. Why must this writ petition wait for 10 years? Right? The moment that comes into the system, code it, send it, segregate it, collect it, and ensure that these matters are disposed of within the shortest. Assign this work to IIT. Pay a consultancy charge to them, assign it to the IIT, and ensure that this is done. Judicial Statistics Act, unfortunately, as a private member's bill, Mr. Nariman introduced it in Parliament, but the BJP government failed at that point of time, and therefore nobody could carry that through. I have twice written to the minister, and for whatever it's worth, I wrote to the Prime Minister also, saying this is a bill that is waiting to be passed in Parliament, please pass that bill. And at that time, the estimated cost of doing that was a mere 10 lakhs. Today it will not even cost you that amount of money. Right? This is very, very antiquated technology we are talking about. It's not even recent technology to enable you to do this. If we are able to do that and segregate cases, I am sure that many, many cases can be resolved at the quickest. So integrate technology at all levels into this system of justice dispensation. And the last thought that I will leave with you is, we need to have good management principles to manage this institution. Justice Ahmadi did it. He called the IIM Ahmedabad and asked them to completely study the Supreme Court and come up with measures which will help them to reduce the pendency of cases. And it worked. It worked for 2 to 3 years. So call IIM Trichy. Ask them to look at who manages our institution. The Registrar General is basically a legally trained person. He is, I'm sure, an amazing judicial mind. But what is his expertise in managing an institution which today has more than 3,000 employees? His expertise at management is next to nothing. Right? Why are we imposing that burden on that poor man? You can afford to, the state government will definitely sign out a check if you say that I want the Indian Institute of Trichy to manage my institute. The Supreme Court observed this in a judgment. And that is why, and then you went the wrong way. You went the wrong way because you appointed managers to the High Court, which is not the way to go. Appoint institutions. Tell the IIM Trichy that I want you to come up with a blueprint for me to reduce my pendency by so much within this year. Fire them if they don't do it at the end of 2 years' time. Don't have an ongoing relationship with any of them. They are retained only to the extent to which they can perform. So bring in better management principles. We have done that as a member of the governing body of Cancer Institute. We have now taken the help of, because Cancer Institute also is huge. It has 1,260 employees. Our annual turnover is 100 crores. So we can't manage this institution like some NGO. We need to bring in professional management. We've brought in the McKinsey to give us a process study to show us what is a process flow, how the patients can be, how we can deliver better results to patients. We are taking a professional look at that. Please, for heaven's sake, do the same to the high courts and to the entire justice delivery system. These are my few thoughts on this topic. I hope it has been useful to all of you. I will just end with a prayer, the prayer from Rabindranath Tagore's Gitanjali, where the mind is without fear and the head is held high, where knowledge is free, where the world has not broken up into fragments by narrow domestic walls, where words come out from the depth of truth, where tireless striving stretches its arm towards perfection, where the clear stream of reason has not lost its way in the dreary desert stand of dead habit, where the mind is led forward by thee into ever-widening thought and action, into that heaven of freedom, my Father, let my country awake. Thank you.
Thank you, sir. Your lecture has covered a broad spectrum on the topic of the role of judiciary from ancient period till now. I hope that we were taken to our own black classrooms where we had a quick glance from Shankari Prasad to Kerala Education Bill. Now, I request the President of MMBA, Mr. SRINIVASA RAGHAVAN, to make an announcement.
In addition to this Quin Decennial lecture series, the chief guest of the day, Mr. N.L. Rajah, senior advocate, has got a pleasant announcement to MMBA. In the fond memory of his senior, late Mr. Govind Swaminathan, he has agreed to sponsor an endowment lecture in an MMBA every year in the first week of October. So we are very happy and grateful to Mr. N.L. Rajah for this, and we assure that we'll make the occasion a memorable one and engage the advocates with a topic of importance, and we will employ eminent advocate and juries and judges to deliver the lecture every day. Thank you very much, sir.
Gratitude is a twofold love. First is love coming to visit us, and the next is love running out to greet a welcome guest. With this quote, may I now request the General Secretary of MMBA, Mr. K.P. Narayana Kumar, to propose the thank quote.
President of the Bar, Most Honorable Chief Guest, Honorable Mr. Justice G.R. Swaminathan, Honorable Mr. Justice Anand Venkatesh, respectable eminent speaker of this function, Founder President Isaac Mohanlal, former President Krishnaveni Madam, office bearers, senior advocates, and my fellow friends. It is a joyous situation to me to express the vote of thanks to our special judge, Honorable Justice G.R. Swaminathan. Your Lordship always extending hands of encouragement to conduct more function on the legal topic to enlighten advocates in various fields. Our gratitude to your Lordship for consenting to hold the chief chair of this function. Thank you, Lordship. Our earnest gratitude to Honorable Mr. Justice Anand Venkatesh, the judge who always pampers Madurai bench, encouraging each and everyone who are appearing before your Lordship. And his presence in this function really made all of us happy. Thank you, your Lordship. History always reminds us to know who we are and what steps should we follow. Governance, executive's good governance will play no role for the judiciary. But if executive's governance fails, judiciary is having no other way except to save society by its intervention. A respectable speaker has touched various spheres on several topics. Jurisprudence of ancient India, judiciary after independence, present status of country, equilibrium to save ecosystem, etc. Respectable speaker, you have made innovative and excellent lecture and enlightened each and every one of us. Thank you, sir. Thank you, sir. Thank you. We are also extending our earnest thanks to former office bearers, senior advocates, fellow advocates, friends, and one and all who kindly participated this function and make this a grand success. Thank you, one and all. Thank you, sir.